Host Ilyas Bulbul here, and I'll be with you for the next hour. As our regular viewers are aware, on Just Law we try and discuss a topic which is of interest to our viewers, and also, more importantly, it gives you the viewers the opportunity to call in and ask any questions that you have on any aspect of English law. Normally we get a lot of questions on immigration law, which is fantastic, but if you've got queries, concerns about any other matters, whether it's personal injury, family, road traffic matters, whatever it is, please do call in and ask us whatever questions that you have, and inshallah we will try and assist you the best way we can. This is a live show, so the number that you can call on will be appearing at the bottom of your screen. So please do pick up your phone, call in, and inshallah let's have a discussion about any questions that you have. Just a couple of points before we get going. As always, as our viewers are aware, it's a live show. We're not able to look at your documents in detail. Unfortunately, we are sometimes not able to take very detailed instructions from you. And so some of the advice that we do give is general in nature. If you need more thorough advice, or if you need more specific advice, then by all means leave your number with the control room, and inshallah after the show I will call you back, or tomorrow or the day after I will make contact with you and we can have a more detailed discussion about your question. And again, it's free of charge. There's no issue about charges at all. Leave your number, we'll have a quick discussion. Indeed, there are many viewers who email me and ask me about matters that we've discussed live on air, and I do try and get back to them and give them the clarification that they want. So that's the only a couple of caveats that I've mentioned. Apart from that, please do call in and ask any questions that you have, and inshallah we'll try and address that. A topic that we've been looking at over the last couple of days, we've not really made much progress on that, is the issue about overstayers. And a couple of weeks ago we looked at the situation where you have an individual who's overstayed, and I explained how there are different laws for those who are under the age of 18, between the age of 18 and 25, and those who are over the age of 25. And we've looked at the different laws that apply and what people can do to try and regularize their stay in the United Kingdom. Generally speaking, as our viewers may be aware, those who are over the age of 25 are unfortunately left with the situation where they are only able to qualify for leave to remain where they've lived in the UK for 20 years. We'll look at that in greater detail after we've taken the first call for the day. Hello, assalamu alaikum.
Walaikum assalam.
Ji brother, jazakallah for calling.
Thank you. I have a quick question regarding spouse visa.
Right, okay.
Now I work part-time,
okay.
And so I was just wondering whether I can show cash savings as well as my income.
Okay.
Right. And if so, do I need to have a letter from the person that's going to gift me some money?
Yeah.
And put money into my account?
Okay.
If that's a good idea, can I put the full amount of cash, or can I just ignore the earnings as well?
Okay, all right. I mean, in terms of the part-time income, what kind of income are we looking at?
About 10,000 a year.
10,000 a year. I mean, the reason that the part-time employment helps is that the more income that you've got, the less obviously you have to show in savings. Mm-hmm. So if I give you an example, if you have no income at all, you would need to show savings of £62,500. But if you have got income in the region of £10,000, then off the top of my head, you would need to show savings of something in the region of about £45,000. Let me just give me 1 second. Let me just do some calculations. 2.5. That sounds about right. It's something in the region of £40,000 to £45,000.
Yeah.
Now, the second question that you're asking is that if somebody has gifted the money to you, do you need to show any evidence of that? Now, in the rules, in the actual immigration rules, all it says is that you need to show the source of the savings, or you may be required to show the source of the savings. Now, the way I interpret that is that you would normally need to do a declaration explaining where the money's come from, or you need to do a letter explaining where the money's come from. So my view is if you do that, that meets the requirements of the rules. However, in practice, I do go further. what I tend to do, if somebody has gifted the money to you, I normally ask them to do a declaration as well. And normally what I try to do is to say that the money has been gifted to you by your parents or your brother, and you know, and just have the gift coming from your immediate family. So for example, if we say that your parents have given you a wedding gift, I would normally do a declaration from them and also show their bank statement showing that the money has left their account, and then obviously showing your bank statement showing that the money's come in. So instead of meeting the strict requirements of the rule and just doing or showing evidence from yourself, I would normally go one step further and provide evidence from the person who's actually providing the money as well, saying, look, I'm providing a gift, this is the gift, and I'm also confirming that it's an unconditional gift in the sense that the money does not have to be returned to me. Now, so I mean, that's what I do in terms of the evidence. Now, thirdly, you are asking, well, should you show any income at all or not? I mean, the advantage of the salaried income or employment income is that it reduces the amount of cash savings you need to show. But the disadvantage is that the Home Office may make inquiries about the employment. So, you know, they may phone your employer to confirm you're working there. Now, if you think that that is going to cause a problem, and if that's the case, then obviously you're better off leaving the employment to one side and meeting the requirements solely by relying on savings. But on the other hand, if they were to make inquiries about the employment and there aren't going to be any issues with what the employer says, what HMRC says in terms of what you've been earning and what their records demonstrate, if there are no issues on that front, then by all means show the income and show the savings. There's less that you need in terms of savings. It's easier to demonstrate. You know, you might have £15,000-20,000 already in your account. It's easier to say, like, look, I've got a wedding gift of £10,000 each from my parents, and that's how I meet the £40,000 requirement, or whatever that may be. I don't know whether that answers your questions or whether you've got any more follow-up questions on that.
No, it answers most of my questions. Just one quick question.
Yep.
Is that does the cash gift, must it come from a family member or can it come from a relative?
Yeah, there's no rule which says it has to come from a family member. It can come from anybody. It can come from a friend. But I think what we have to bear in mind is wherever it comes from, what we don't want is the entry clearance officer to look at it and question the genuineness of the gift. So generally speaking, what I tend to do is to say it's from very close family members, which you know, uncles, aunts, parents, maybe brothers and sisters, who are well off. So then it's more plausible that somebody would give that gift. Now, maybe it's plausible that somebody who's a second, third cousin might give money, but it just makes it less likely in this day and age for somebody to give an unconditional gift, you know, as opposed to a loan. So if it comes from a close family member, it is more plausible. And in my experience, where it has come from family members, it hasn't been challenged by the entry clearance officer when they've looked at the application. They looked at your bank statement and said, yes, the money's come in. They looked at the parents or the brother's bank statements to say, yes, the money has been transferred. And then it's not been an issue. The other way I've dealt with it is to say it's not a gift, it's from the sale of something. So sale of land in India, Pakistan, you know, money's come in, and because the money doesn't have to be in your account in the UK. It can be in the account of your husband or wife or whoever the applicant is. I mean, in your case, your wife. It could be in your wife's bank account in India or Pakistan. So if there's an explanation as to where the money's come from, it may not be a gift, but it may be from the sale of a car, sale of land, sale of a house, and what this person is getting is their share of the sales proceeds. So that may be another way of how the money has come into the account. And again, you just demonstrate the source by showing the deeds, etc., showing the transfer of money as well. So, but whatever you do, what you've got to do is, I mean, you can look at this yourself and look at whether what you're saying, whether it's plausible or not. to somebody who's looking at this objectively, looking at these documents objectively, does it look plausible or not? Brother, thank you very much for your call. Hope that answers your question. We'll take our next call. Hello, Assalamu alaikum. Hello. 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 जी आवाज़ आ रही है जी भाई, you're live on air जी, what's your question?
दो सवाल है मेरे छोटे-छोटे।
जी।
ये कि मेरे बेटे ने अपनी वाइफ का स्पाउस वीजा अप्लाई किया लास्ट वीक पाकिस्तान से
जी।
तो वो प्रीमियम सर्विस की भी फीस हमने दी है, तो
जी।
ये मैं पूछना चाहता था कि उसमें ज्यादा से ज्यादा कितना टाइम लग सकता है? कुछ लोग तो कहते हैं कि हफ्ता 10 दिन में आ जाता है उसका डिसीजन। और दूसरा मैं ये पूछना चाहता था कि मेरी बेटी ने नेशनलिटी की एप्लीकेशन करनी है और वो अगर एप्लीकेशन ड्यूरिंग एप्लीकेशन वो पासपोर्ट अपना ओरिजिनल नहीं भेजती, चेक एंड सेंड सर्विस के जरिए भेज देती है, तो ड्यूरिंग द एप्लीकेशन वो पाकिस्तान ट्रैवल कर सकती है?
जी।
कोई इसमें कोई मसला उसकी एप्लीकेशन पे तो नहीं होगा? ये दो सवाल हैं।
जी जी भाई, जज़ाकल्लाह।
जैसे मैं टीवी पे सुनता हूँ, अगर कोई क्वेश्चन पूछना तो पूछ लें।
जी ठीक है, जज़ाकल्लाह। नहीं, आपका क्वेश्चन वेरी स्ट्रेट फॉरवर्ड, मैं अभी आपको आंसर दे दूंगा जी, ठीक है, जज़ाकल्लाह, थैंक यू फॉर योर कॉल। नाउ इन रियलिटी द इशू अबाउट हाउ लॉन्ग द प्रीमियम सर्विस टेक्स, वो तो रेगुलरली हमको लोग पूछते हैं कि हमने प्रीमियम सर्विस के पैसे दे दिए स्पाउस एप्लीकेशन के लिए, कितना टाइम लगेगा? The reality is that the current processing time is in the region of about 4 to 5 weeks. जब उसने ये शुरू किया था ये प्रीमियम सर्विस, if we go back about 8-9 months, तो at that time हाँ जवाब उसके आ जाते थे within a month, within a week, within 2 weeks. But current processing time is around 4 to 5 weeks. And those 4 to 5 weeks start not from the date the person goes to give their biometrics. Pakistan mein, when they go for their fingerprints and they submit their passport, the time doesn't start from then. In my experience, the time starts from when you actually submit the document. So generally, it's about 4 to 5 weeks from when the documents are submitted to Sheffield. Second your question tha regarding nationality applications and whether when the nationality application is pending, whether the applicant can leave the country or not, because you can use the nationality check-in service, they only take a copy of the passport, they return the original to you. Can you leave the country whilst the application is pending? The answer is yes. There is no problem whatsoever in the applicant leaving the country whilst the nationality application is pending. So आपने जो पूछा था सवाल के वो कंट्री से बाहर जा सकते हैं या नहीं, डेफिनेटली कंट्री के बाहर जा सकते हैं जब उसका nationality का application pending है. I think the reason why people ask this question is that generally when a normal immigration application is submitted for a visa or for indefinite leave, when a normal visa application is submitted, you cannot leave the United Kingdom. If you were to leave the United Kingdom, the effect of you leaving on the application is that would cancel the application at that stage. Now, but there is a difference with nationality applications. Nationality applications are treated differently. There is no problem with you leaving the country whilst the nationality application is pending. वो आपके application पे कुछ भी effect नहीं होगा. Thank you very much for that call. Now, just returning to the subject which is to do with overstayers, and as I explained in the previous shows, where somebody is over the age of 25, it is very difficult for them to regularize their stay in the United Kingdom. They normally have to stay in the UK for 20 years, and after 20 years, even when they apply, they are not granted indefinite leave. They are granted a 2.5-year visa to stay in the United Kingdom, which is extended on numerous occasions until the person has spent a total of 10 years in the United Kingdom, and it's at that stage. So in reality, it's when they've spent 30 years in the United Kingdom when they qualify for indefinite leave. We've covered that subject a couple of times on the show before. What I want to do today is look at where somebody is here as an overstayer, maybe single, but they've reached a situation where, mashallah, they've managed to find somebody to get married to, or they've already got married, and whether that changes their status in the United Kingdom, whether that increases the possibility of obtaining some kind of leave in the UK. I want to look at that subject now. But as I've said before, it's a live show, so there is a number that appears at the bottom of the screen. So if you've got any questions, do call in and we'll deal with that. Now, looking at somebody who is going to get married or who has already got married, and assuming that the partner is somebody who has a British passport or who has indefinite leave to remain. Now, will that marriage be enough to assist the person who's overstayed in obtaining some kind of leave in the UK? Now, in my experience, it depends on the nationality of the person that the person is getting married to. If that person is British or has indefinite leave to remain, unfortunately, marriage in itself won't be enough. So if you've overstayed and you're getting married to somebody who's British or who has indefinite leave to remain, marriage, generally speaking, on its own is not enough. Contrast that with a situation where somebody who's overstayed gets married to somebody who has a European passport. So in terms of the European passport, what we mean is somebody who may have French nationality, Spanish nationality, Hungarian nationality, etc. Any European nationality apart from nationality of the United Kingdom. If you get married to a European national, then marriage in itself is enough to assist you in regularizing your stay in the United Kingdom. So we've got two possibilities here. One is somebody who's getting married to somebody who's British, who has indefinite leave, and for them marriage isn't enough. And then on the other hand, you've got somebody who gets married to somebody who has European nationality. For them, marriage is enough to get them stay in the United Kingdom. So obviously it's not as simple as that. Even for those two categories, we need to look at matters in greater detail, and that's what I want to do in the next few minutes. Now, let's now concentrate on the category where somebody is getting married to somebody who has British nationality or has indefinite leave to remain. Marriage, generally speaking, is not enough, but in my experience, there is sometimes some flexibility that's operated by the Home Office. Albeit it's limited flexibility, and in my experience it is where the person in the UK, the British person, has some kind of illness and the applicant needs to, whilst they're married living together, the applicant actually looks after them, and by looking after them it means that the person is able to live here without relying on extra support from the council, without relying on extra support from public funds. So in that situation, even if the Home Office rejects the application based on marriage, it's very possible that you will be granted a right of appeal, and it is possible that the tribunal may look at your case more favourably. We'll look at that in greater detail after we've taken the next call. जी, hello, अस्सलाम वालेकुम. जी भाई, what's your question? Hello.
Hello.
जी भाई, you're live on air. What's your question?
Hello.
Hello.
Can you hear me?
Yeah, I can hear you. Yep.
Yeah. Sorry about that. There's you was talking about just a few minutes ago.
Yep.
Regarding about European and British.
Yes.
And my wife, she's Filipino, and she got indefinite leave.
I understand.
And I'm illegal. So will I get in the UK, or do I have to go back?
Yep. What I was going to look at is where. So what I was saying was that marriage to somebody who's British and somebody who has indefinite leave on its own won't be enough. On its own, there has to be something else, and that something else, in reality, is where there are children involved. Now, if there are children involved, then even though the wife only has British nationality or has had indefinite leave to remain, but because there are children, that means that it is possible to get leave to remain in this country based on the wife being British or having indefinite leave and there being children.
I got one baby British.
So it's the baby that is British that makes all the difference, because marriage in itself is not enough. Because a lot of the times we get queries saying, look, I'm getting married to somebody who's British, can I now just change my status in the United Kingdom? In reality, no, you can't. Until there is a baby, who's British, there is no point whatsoever in making the application. MashaAllah, from what you're saying,
baby makes big difference.
Huge difference. It just changes the application completely. Because there, what the rules say is that if your partner is British and you have a child who is British, then you should be granted indefinite leave to remain if you are legally married to your wife. Now, if you're not legally married to your wife, in reality, the Home Office will still grant you leave to remain in the United Kingdom. Because the rule is this, that in a situation where the couple aren't married, the rule is it reasonable to send a British child back to your home country, which I'm assuming might be Pakistan. Let's assume it's Pakistan. So is it reasonable to send a British child back to your home country? And the courts have said it is not reasonable to expect a British child to leave his or her own country. So because of that, because of what the courts have said, the Home Office is stuck. And where there is a child, they have to grant the parent leave to remain in the United Kingdom. So I always say to clients, look, you've got married, mashallah, fantastic. First step is completed. Just wait until there's a baby. But in your situation, obviously, there's a baby. So there is no harm in making the application. And there's no reason why your application can't succeed. So inshallah, I hope that answers your question. Thank you very much for your call. I think what the caller prompted us to do is move on to the next bit of the show, which was, if you're married to somebody who's British or who has indefinite leave, then when is it that you may qualify for leave to remain? And it is, as we discussed with the caller, it is where there is a child who is British. So we've sort of looked at that in answering the question from our caller. After the short break, we're going to look at the position where somebody gets married to a European national. Inshallah, we'll be back in the next few minutes, just after a short break.